This is Barry Zalma on Insurance. I'm an attorney who is retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to talk some more about the development of the tort of bad faith. In California, the courts began the transformation of the breach of the doctrine of good faith and fair dealing from a contract remedy to a tort remedy, primarily through 6 cases spanning a 21-year period. These bad faith cases were based on traditional tort concepts like duty, breach of duty, and proximate cause. The courts found that the precise nature and extent of the duty imposed by such an implied promise will depend on the contractual purpose, and a breach of the duty leads to imposition of contract damages determined by the nature of the breach and standard contract principles. One of the first, Comunale versus Traders and General Insurance Company, was decided by the California Supreme Court in 1958 and concluded that the insurance company wrongfully refused to defend its insured, who had been sued in the underlying action for damages arising out of an automobile accident. It also refused to conclude the suit after receiving an offer of settlement for about 25% of the actual and ultimate judgment obtained against its insured. The refusal resulted in an excess judgment against its insured. In the subsequent bad faith action, the insurer was held liable for the entire judgment, including that part of the judgment excess of the limits, plus other resulting damages. This was clearly an extra-contractual recovery, since under a straight breach of contract claim, the insurer would have been liable for only the amount of the policy limit. The court held for the first time that the insurer's conduct amounted to a tortious breach of the implied covenant. At least the decision has been so characterized by subsequent authority. The direct comments on the issue by the Comunale Court were in the context of a discussion of the proper statute of limitations to apply. The court concluded that an insurer who wrongfully declines to defend and who refuses to accept a reasonable settlement within the policy limits in violation of its duty to consider in good faith the interest of the insured in the settlement is liable for the entire judgment against the insured, even if it exceeds the policy limits. The court also noted that since an insurer who has undertaken to defend a third-party claim may be liable for a judgment in excess of policy limits, where it has wrongfully refused to settle within those limits, an insurer who, in addition, wrongfully refuses to defend should be in no better position. In 1964, the California Court of Appeal decided a case called Chrissy versus Farmers Insurance Group, which arose when an injured person who had recovered a judgment against an insured brought an action as assignee of the insured against the insurer. The Court of Appeal held that the assignment by the insured to the injured person of any right of action the insured might have against his insurer for unreasonably rejecting the injured person's settlement offer to the insurer would subject the insurer to liability for the amount of recovery by the injured person against the insured in excess of the policy limit, if the insurer acted in bad faith in rejecting the offer of settlement. The court held that a wrongful refusal to settle sounded only in contract was expressly disapproved. The court stated that in determining whether to accept a settlement offer, the insurer must give the interest of the insured at least as much consideration as its own. When there is a great risk of an excess judgment, good faith requires acceptance of an offer within policy limits. The Court of Appeal concluded that if bad faith occurred before the assignment, the action could be maintained by the assignee. More recently, the U.S. District Court found in Cash v. State Farm, a 2000 decision of the Middle District of Alabama, applying Alabama law, the court held that an assignment of a bad faith claim violates public policy and is not enforceable. Alabama recognizes bad faith as tortious conduct, not contractual. Because tortious conduct is intentional, fraudulent, and personal, it cannot be subject of an assignment. The court concluded that the insured had the right to assign their claim for breach of contract, but not their claim for tort damages. In Texas, on the other hand, the court in Westchester Fire v. Admiral, a 2003 decision, found that punitive damages are actually insurable and assignable. It isn't always wise, therefore, to take a judgment subject to a covenant not to execute. Some litigants and lawyers believe they hit the jackpot when an insurer wrongfully refuses to defend, opening up its policy limits and conditions to infinity, as did the insurer in Crits. They think they can pick any number that appears to be reasonable and will be able to collect it as bad faith. This is not the case. The judgment must be reasonable and based on actual provable evidence. In 1967, the California Supreme Court decided Chrissy v. Security Insurance Company, a case filled with unreasonable actions. Chrissy, an underinsured landlady, was sued by a tenant who fell down a staircase. Her liability policy had a limit of $10,000, which was 25% of the $40,000 in claimed damages. However, prior to trial, the tenant's demand was substantially reduced, and he expressed a willingness to settle the case for $10,000. In spite of strong evidence of both liability and substantial damages, the defendant insurance company refused to settle for more than $3,000. A final settlement offer of $9,000, of which Chrissy herself agreed to pay $2,500, was likewise rejected. Following a jury trial in the underlying action, the tenant received a judgment of $100,000, of which the insurance company paid the $10,000 policy limit. Chrissy was unable to pay the remaining $9,000 and was rendered indigent. This disastrous change in her financial circumstances was accompanied by a decline in her physical condition, hysteria, and suicide attempts. She eventually brought a bad faith action. The court, in affirming a judgment in favor of Chrissy for not only the underlying unpaid judgment of $90,000, but also $25,000 for emotional distress, expressly held that the insurance company's refusal to settle was wrongful, was a breach of the covenant of good faith implied in the policy, and sounded in tort. The court held that in determining whether an insurer has given consideration to the interests of the insured, the test is whether a prudent insurer without policy limits would have accepted the settlement offer. This test should be applied by all insurers when evaluating an offer of settlement to avoid the trap that Security Insurance Company fell into when it insisted on taking Chrissy's case to trial. The court also held that recovery of emotional distress damages arising from injury to property interest was proper. Under the circumstances of the case, there was a clear tortious invasion of Chrissy's property interests. Indeed, when Chrissy purchased her policy, she was obviously seeking freedom from the very financial insecurity and resulting emotional distress which in fact occurred. Similarly, in American Hardware versus Harley-Davidson of Trenton in 2005, a district court held that the bad faith results from failure to actively negotiate a claim. The court found the insurer acted in bad faith because, 1, the chances of prevailing at trial were set at 30 to 40%. 2, the plaintiff would likely settle for between $250,000 and $350,000. 3, the defense counsel reported that the policy limits were $500,000. And 4, the defense counsel reported that the plaintiff had demanded $497,000, a sum less than the policy limit. Also, the insurer never attempted to enter into settlement negotiations with the plaintiff's counsel, and the insurer never offered more than $100,000 to settle the claim. The jury returned a verdict of $1.4 million. The court found that the insurer acted in bad faith because it failed to actively negotiate the underlying claim, particularly where it received information that the plaintiff was likely to settle for $250,000 and counsel had advised the value of the case was in excess of the $100,000 offer. Thus, they were ignoring the advice of the lawyers they hired to defend their insured. This case is an example of why an insurer should not ignore the advice of its insured's defense counsel, because doing so can cause the insurer to pay a massive verdict on behalf of the insured, in addition to emotional distress and punitive damages as punishment for its failure to settle. An insurer's failure to accept a reasonable settlement offer to resolve a third-party claim against its insured constitutes a breach of the covenant of good faith and fair dealing implied in the liability policy. The ultimate judgment was over 2.5 times the policy limit and resulted from the insurer's failure to accept the plaintiff's multiple offers to settle for a sum within the limit. The statute of limitations was not applied because the contract action was equitably tolled while appeal in the underlying action was pending. Because a liability insurer's duty to accept a reasonable settlement offer causes no damage to the insured until entry of an excess judgment. The insured's damages cannot be certain until the judgment is final or the time in which to appeal has passed. This is so because if the insured appeals a trial court judgment in favor of a third-party claimant for damages that exceed the insurer's policy limit, that appeal may result in a reversal of the judgment against the insured or a modification of the judgment that reduces damages to an amount below the policy limit. Thus, until the judgment is final, it cannot be determined with certainty whether and in what amount the insured has been harmed, if at all. This video was adapted from my book, Zalma on Insurance Claims Part 106, Second Edition, which is one part of a 10-part treatise called Zalma on Insurance Claims, and which is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be of interest or useful to you, please forward it to your colleagues. It's free. And please subscribe to my Rumble channel, my YouTube channel, and my blog so that you can be advised of future videos and future blog postings. Thank you for your attention.